Welcome, sir. We'll start off with our panel with Attorney Diokno, who's going to talk to us about judicial capture in the days of martial law.
Hindi pa naman ako lolo ah. Pwedeng woke tito na lang. What I propose to do this morning is to trace how lawfare has plagued our country for over 100 years. This is something that we talk about today, but actually has been happening for decades, more than decades. And perhaps we can learn from our history, we can learn from the past how best we can deal with the weaponization of the law. I have some slides. Next slide, please. I have, thank you. We can trace the use of the law as a weapon to stifle dissent way back to the Spanish and American times. I need only name a few of those who were victims of this kind of weaponization, and I think you will understand how it was wielded. We have, of course, the three priests, Fathers Mariano Gomez, Jose Burgos, and Jacinto Zamora, tried and executed for treason and sedition in 1872. We have our revered hero, Jose Rizal, tried and executed also for sedition and rebellion in 1896. Aurelio Tolentino, who is honored in our cultural center, who was actually arrested 9 times by both the American and Spanish regimes. And one of the last of our Katipuneros, Macario Sakay, charged with banditry and executed in 1907. But I think the best example of lawfare in our country is none other than Ferdinand Marcos and his dreaded martial law dictatorship. Because he really replaced the rule of reason with the rule of the rifle. He was responsible for, I quote, creating an oppressive climate of fear, obsequiousness, and corruption that all but smothered the impartial administration of justice. This is rarely talked about, but actually we can also give credit to Marcos for completely destroying judicial independence and for perverting our legal profession. Let's go back. One week after he declared martial law, he issued Letter of Instruction number 11, requiring everybody in government, including all judges, to submit letters of resignation that he could accept at any time. Hindi pa siya nakontento doon. A few months later, he enacted a new constitution, so-called, which contained a provision that said that all judges, including the members of the Supreme Court, will remain in office until the age of 70 unless or until he decrees otherwise. And with that, I think no kind of lawfare, weaponization of the law can ever be successful when you have an independent judiciary. And so from here, we can understand that before he embarked on using the law as a weapon, he first neutralized the judiciary. What was the impact of the LOI 11 and the change in our Constitution on the judiciary, on our legal system? Well, I guess we can call it judicial capture. For 14 years, Marcos owned every single judge in the country. He could remove them at any time, for any reason, or even without any reason, and he did. I quote from the State of the Nation after 3 years of martial law by the Civil Liberties Union of the Philippines. Mr. Marcos can replace any judge anytime he is disposed to do so, and in fact has repeatedly done so. Veteran judges of long service have been dismissed through court notices of acceptance of their compulsory resignations. Can we now view the judiciary as independent, able to protect the litigants and those accused of crimes with no other end in view but truth, justice, and fair play. I wish I could end there, but actually, if you think about it, by capturing the judiciary, Marcos captured the entire legal profession, and he transformed it. He created mutant lawyers, glorified fixers who won their cases not because they had merit, but because they were close to Malacanang. These fixers established networks among law, other lawyers, among prison officials, big business, and so forth, that have outlasted the Marcos dictatorship and that still operate today. So that is the real legacy of martial law, insofar as our legal system is concerned. But I have to say that martial law also gave rise to another kind of lawyer. What was disparagingly called at the time the human rights lawyer, these are the people, the very few brave and courageous people who fought for us during the darkest time of martial law. And I tell this to all the young people. Can I call you my children? I tell them all that we should never forget those few courageous souls who fought for us during the darkest times of martial law. If not for them, the freedoms we enjoy today would not even exist. But now, our freedoms and democratic institutions are again under attack. And they're using all sorts of weapons. Real weapons, guns to kill in the name of the war on drugs, drug lists to sow fear, silence dissent, and destroy judicial independence. I think you remember that one of the names in the very first drug list of President Duterte was the name of a dead judge. And us in the legal profession, we laughed because we said, how can you include the name of a dead judge in a narco list? But think of it from the point of view of a living judge. They must have thought, kung yung patay na nga na judge ay naisama na sa listahan, paano pa kami nabuhay pa? Another weapon that has been unleashed by this administration is the use of trolls to capture the online conversation, make it harder for us to speak freely. But to me, the biggest weapon that they are now wielding is the law. Because this is really an effective weapon as far as putting critics in jail, removing them from office, and silencing the press. And this is just a few, I think, of the examples that we can think of how the law has been weaponized in our time. Number one, the unjust imprisonment of Senator Laila de Lima. Second, the sedition and other criminal charges against Senator Trillanes, the candidates of the Ocho Derecho, Vice President Leni Robredo, among others. Third, the quo warranto case that was used to oust Chief Justice Sereno, the criminal and civil cases used to neutralize Rappler and go after Maria Ressa, put a chilling effect on other news organizations, and of course, the latest, the quo warranto case against ABS-CBN. How then can we push back? Some of us tend to take a spectator point of view. We complain a lot, but maybe don't do as much. But we can learn a lot from the lessons of the past, particularly martial law. Because the lawyers who stood up for our rights during martial law realized one thing, that just as the law can be used to oppress, the law can also be used to empower. And the law can also be used to liberate. What was the strategy that human rights lawyers employed at that time to fight the weaponization of the law? Well, it was really a two-part strategy. First, to confront the regime with, number one, the detrimental effects of its policies and programs on the people, the inconsistencies between the policies and actuations on the one hand, and the aims and principles the administration professes on the other, as well as standards that are internationally accepted. And we did this at the time, for example, by challenging government at every turn, whether in court or out of it, for usurping or impairing the sovereignty of the people. by urging an interpretation of the law different from the official interpretation to favor the rights of the poor, by challenging policies, citing constitutional provisions, public utterances of government officials, and international obligations. And in all cases, by documenting as thoroughly as possible the effects of what is happening to show the world that they are so detrimental and blatantly unfair that they are shocking to the conscience. And I think we can do this even today. The same strategy that we used to defeat a dictator before can be employed as well today to defeat someone who wants to believe that he is a dictator as well. What is the strategy based on? And I think this is important. It's based on two beliefs. First, that those in government, no matter how oppressive they may be, are not all evil. Like all of us, they're a mixture of good and bad, so that appeals to the conscience are not predestined to fail. And second, that governments seek the respect of other governments and also their aid. To obtain that, they need to maintain some semblance of legitimacy, and that is where they have a weakness. The second part of the strategy is to help the poor, as members of their communities and sectors, become aware of the causes of their situation and organize and mobilize themselves to overcome these causes. And again, this strategy is based on two beliefs. Number one, that the power of government ultimately rests on our fear and submissiveness. Your very force is nothing but my fear, and can be neutralized by developing that sense of self-respect in people that deny submission, the self-respect that is, quote, the basic power ingredient behind the great Asian revolutions of our time, the poor man's power, Asian power, human power. The second base of this strategy is the belief that just as law can and has been used to foist inequality and injustice, it can also be used to establish social justice and equity. But to do this, I think we cannot be the leaders of this movement. We need to help our people organize and mobilize themselves and empower themselves. Because it is only when they act on their own that we can say that we are a real democracy. What tactics do we use to implement this strategy? Well, we in FLAG have been doing this for more than 45 years. We educate, we inform the people of their rights, we show them how these rights are often inadequate or inadequately enforced. We search with our clients the causes of these inadequacies and together attempt to devise legal and social solutions. But the process of searching for causes and devising solutions is in itself empowering, and that in itself is the beginning of development. But that is not enough. That heightened sense of awareness has to be converted into action, and that action must be well organized and as broadly based as possible. In our experience fighting a dictatorship, we realized that fighting the courtroom battle was not enough, that legal tactics were insufficient. That's why we developed that concept of meta-legal tactics. Nonviolent group actions that transcend normal legal procedures, yet remain faithful to the basis of law. And these are the lessons that we have learned from fighting and defeating a dictatorship. I see no reason why we cannot use similar strategies and tactics today. I do not subscribe to that feeling of hopelessness that I've heard from several people, because to me, resistance is not futile. In fact, it's vital to preserving our democracy. And if there's one final lesson we can learn from the past, it's this: walang forever sa Malacanang. Thank you.
Thank you very much, Attorney Diokno. Meron pa tayong hugot line. Walang forever kahit sa Malacanang, kahit feeling mo sa EDSA on a Friday night, meron.